Professor Tom Reed, Director of the Widener Veterans Law Clinic. I have another question that I think may be on some people's mind. We occasionally talk to a veteran who had some trouble in the service and didn't get an honorable discharge. We take those cases and try to correct discharges when there's a legal basis to do so. Now, 99% of all veterans get what's known as an honorable discharge, which entitles them to full veterans benefits from the VA hospitalization, and federal, state, and local hiring preferences for being a vet. Some veterans whose record wasn't quite up to par will get what's known as a general under honorable conditions. That discharge isn't dishonorable by any means, but it does do one bad thing. It cuts off your Montgomery GI Bill rights, and in most states it takes away your veteran's preference for hiring. The third kind of discharge, and these are the discharges we work with most often, are less than honorable discharges given for bad behavior. They're issued administratively. There's a process that must be followed by each of the armed services in discharging someone administratively for bad behavior. And if that's not followed according to the regulations of the service, then your discharge is contrary to law and it can be set aside. Typically, these kinds of discharges are given to veterans who have a record of petty offenses, office hours, captain's mast, but no serious court-martial offenses. They're generally considered to have been not up to par and not good soldiers, sailors, air persons, or Marines. Now, the next two kinds of discharges are those that are given to people by a court-martial. They're more difficult to deal with and oftentimes cannot be set aside. If you have been court-martialed by a special court-martial, you got a bad conduct discharge. That discharge, of course, deprives you of all veterans' benefits across the board. Those are very difficult to change because ordinarily court-martial decisions are reviewed twice, first by the officer who convened the court-martial for legal error, and then by the Court of Criminal Appeals for the Armed Services for errors of law. And it's very difficult to find anything upon which to base an appeal if that process has been followed according to the rules. Finally, the worst kind of discharge you can get is a dishonorable discharge. That, of course, occurs when a general court-martial finds you guilty of a very serious crime, such as would be a civilian felony. That, again, is automatically reviewed by two different levels of reviewing authorities before it becomes final. Those two are extremely hard to set aside. Now let's talk for a minute about the process of setting aside a discharge for someone who got an administrative discharge for unsuitability, undesirability, or bad conduct. There are two boards in every service except the Coast Guard that deal with these issues. If you've been out less than 15 years, you have a right to go before the Discharge Review Board. The Discharge Review Board can change the character of your discharge on two grounds: irregularity in the administration of the original discharge, or equity, that is subsequent good behavior as a civilian. We've taken cases on both grounds. We've succeeded in cases where we had both an equity ground and a substantive error in procedure in the original discharge and getting that discharge reversed. If you've been out more than 15 years, you must go to the Board for Correction of Military Records for your service. This is a application form that begins with form DD-149. DD-149 form is a one-page form, pretty easy to complete. But filing that form isn't going to help you win. What you need to do when you apply for change of discharge, and what this program does, is gather up your medical records, your civilian records, obtain statements of good character from people in your community who know you, and fully brief the issues that look like they're errors of law in administering the discharge. One of the great areas of error is the failure to obtain written waiver of an in-person hearing before you are discharged. All military services permit you to do that, but if there's no waiver form in your packet and you never signed any waivers, you were discharged without a hearing before a board of officers, that's an irregularity that can cause your discharge to be overturned and a possible honorable discharge resulting from that. Now there's another group of veterans who can take advantage of discharge review. If you had an illness or an injury in service and you were not subjected to the military medical board review system before you were discharged, you can come back in to the Board for Correction and Military Records of your armed service and ask that board to do what should have been done in the first place. Have your case medically reviewed and a decision made as to whether or not you're entitled to disability retirement at half pay, tax-free, or severance pay, 1 year's pay tax-free, as a result of your injury or disease. We've had fair success with that. The problem we generally have is that the cases we represent people who have been out of the service many, many years and their condition was latent and didn't manifest itself during the service by any overt acts. Those are very difficult to win. But those are the two cases in which you can apply for a change of discharge to the appropriate administrative board. They're type of cases that we do handle, and if you want more information on this, please contact us.